Hello everyone, welcome to MAYANK LAWHOLIC. This is the last and the final part of previous year question paper of 2019 HJS of Delhi Judiciary. So let's get started. Question number 104. A claim by an employee under the Payment of Wages Act 1936 has to be preferred within which of the following periods from the date it is due or from the date on which any unauthorized deduction has been made. Options are 3 months, option second 6 months, and option third 1 year, and option 4 3 years. Correct answer is option number 3, that is 1 year. Now let us see the question number 105. Under the Minimum Wages Act 1948, the maximum compensation which the competent authority is empowered to grant to an employee while allowing his claim arising out of payment of less than the minimum rate of wages is, option is double the differential amount, option second 4 times the differential amount, option third 10 times the differential amount, and option fourth equivalent to the differential amount. In this question, correct answer is option 3, 10 times the differential amount. Let us see the question number 106. A person aggrieved by an order passed by the Commissioner under the Employees Compensation Act 1923 awarding a lump sum compensation, interest or penalty can avail which of the following remedies? Options are raise an industrial dispute before the Labour Court, option second appeal before High Court, option third appeal before District Court, and option 4 appeal before the Central Government. In this question, the correct answer is option 2, appeal before the High Court. Question number 107. The employer is liable to pay compensation to employee under section 3 of the Employees Compensation Act 1923 if a personal injury sustained by the employee during the course of his employment results in his total or partial disablement exceeding options 2 days, 3 days, 1 week, 10 days. Correct answer is 3 days. Question number 108. As per the Factories Act 1948, an employer must provide a canteen for the use of its employees if the number of the workmen employed in the factory is more than 250. Correct answer is 250. Now question number 109. As per the Factories Act 1948, every adult who has worked for a period of 240 days or more in a factory during a calendar year is entitled to leave with wages for the following number of days in the subsequent calendar year. That is, options are 1 day for every 20 days of work performed during the previous calendar year, option second 1 day for every 15 days of work performed during the previous calendar year, option third 1 day of every 30 days of work performed during the previous calendar year, and option 4 1 day of every 90 days of work performed during the previous calendar year. In this question, the correct answer is option number 1, that is 1 day for every 20 days of work performed during the previous calendar year as per the Factories Act 1948. Now let us see the question number 110. As per the Factories Act 1948, in every factory a crèche by way of a suitable rooms for children under the age of 6 must be provided in case number of women employed is more than, answer is 30. Third option is the right answer. If there are 30 women working, then the facility of crèche should be provided as per the Factories Act 1948. Children below the age of 6 years. Now let us see the question number 111. The maximum number of weekly hours for which an adult worker can be required to work in a factory as per the Factories Act 1948 is 48 hours, 50 hours, 52 hours, 54 hours. Maximum number of weekly hours, correct answer is option 1, 48 hours. Now let us see the question number 112. The PF account, Provident Fund amount which an employee can withdraw within 1 year of his retirement in accordance with the provisions of Employees Provident Fund and Miscellaneous Provision Act 1952 provided he has attained the age of 54 year. Option 1 is 25% of the amount standing to his credit, option 2 50% of the amount standing to his credit, and option 3 90% of the amount standing to his credit, and option 4 100% of the amount standing to his credit. Here the correct answer is option 3, 90% of the amount standing to his credit. Now let us see the question number 113. Damages recoverable under section 14B of the Employees Provident Fund and Miscellaneous Provision Act 1952 from an employer for default in payment of the contribution in the fund can be up to, option are 25% of the amount of arrears, option second 10% of the amount of arrears, and option 3 50% of the amount of arrears, and option 4 100% of the amount of arrears. Here the correct answer is option 4, 100% of the amount of the arrears. Now let us see the question number 114. Option 1 is His amount of theft at his house was quite dash. Option second, do not be so dash that you believe in everything your leader says. Option 3, although a novice, his performance in debate was quite dash. The three sentences above can be filled most appropriately in the correct order as. The options are, we have to find with the correct order, which can be filled in these blanks. Here the correct answer is option 3, because the meaning of credible in Hindi is vishwasniya, and credulous, the meaning of credulous is trustful. Creditable means prashanshaniya, someone to be praiseworthy. Question number 115. If the evidence dash, the charge will be indicated. The above blank can be filled in the most appropriately with the phrase. Option 1, bears up, bears out, bears with, bears away. Okay, here the correct answer is option second, bears out. If the evidence bears out, the charge will be indicated. Now let us see the question number 117. Such sort of slavish discipline makes a slavish temper. The child submits and dissembles obedience, whilst the fear of the road hangs over him. But when that is removed, and by being out of sight, he can promise himself impunity, he gives the greater scope to his natural inclination, which by this way is not at all altered, but on the contrary heightened and increased in him, and after such restraint breaks out usually with more violence. John Locke. Which of the following best expresses the essence of the above passage? Here in this question we have read the passage which was written by John Locke. We have to give the correct answer which is related to this passage. So the options are, spare the rod and spoil the child. Children dissemble obedience but naturally given to disobedience. Children have to be restrained, otherwise they become violent. Excessive discipline is harmful for children and makes them even more indisciplined. This is more appropriate relating to the passage we have read. Option 4. Correct answer is option 4, 118. The word pulchritude means beauty, oddness, complexity, stubbornness. Here the correct answer is beauty. Which Constitutional Amendment Act relates to the introduction of GST? This is a very important question asked in various examinations. Correct answer is Constitution 101st Amendment Act. Now let's see the question number 120. Which article of the Constitution of India incorporates the doctrine of pleasure in connection with the tenure of office of a member of the civil services of the Union or state or a person holding civil post under the Union of a state? Options are Article 310, Article 312, Article 320 and Article 323A. Here the correct answer is Article 310. Article 310 is the correct answer, and Article 310 of the Constitution of India incorporates doctrine of pleasure by clearly stating that every person who is a member of a defense service or of a civil service or of the Union of an all Indian service or holds any post connected with the defense or any civil post under the Union holds the office during the pleasure of the President. Now let us see the question number 121. The judgment of the Supreme Court of India in the matter of Minerva Mills Limited versus Union of India reported in 1980 pertains to option 1, constitutionality of the provisions of the Constitution 25th Amendment Act. Option 2, constitutionality of the provisions of the Constitution 39th Amendment Act. And option 3, constitutionality of the provisions of the Constitution 42nd Amendment Act. And option 4, constitutionality of the provisions of the 44th Amendment Act. In this question, the correct answer is option 3, constitutionality of the provisions of the 42nd Amendment Act. Now let us see the question number 122. First woman chief minister was from which of the following Indian states? Option are West Bengal, Uttar Pradesh, Tamil Nadu and Kerala. Here the correct answer is option number 2, Uttar Pradesh. First woman chief minister was Suchita Kripalani. She was the first chief minister of Uttar Pradesh, and her tenure was from 1963 to 1967 in UP. Okay, and one more thing I want to add, first woman governor, and that will be Sarojini Naidu. Now let us see the question number 123. The best motion picture award for the Oscar 2019 was awarded to. This was the question related to current affairs. Here the answer is Green Book, but if in case there is the question again came of similar pattern and was asked who was the given best motion picture award for 2021, then the correct answer will be Nomadland. Okay, now let's see the question number 124. The current president of the World Bank Group is. Options are David R. Malpass, Antonio Guterres, Tom Wilkinson and Mikhail Mishustin. Correct answer is David R. Malpass. This is the correct answer, and he is the president of the World Bank Group. Now let's see the question number 125. Again, this question is related to current affairs. The Royal Swedish Academy of Sciences awarded the Severance Risbank Prize, the Economic Sciences, in the memory of Alfred Nobel Prize 2019. Basically, they are asking the Nobel Prize winner in economics for 2019. For 2019, the correct answer, as we all know, because one Indian, Abhijit Banerjee, and his wife, AILET Deflo, was the co-winner in economics. So this is a very important question we all must know. And with him, Mikhail Kremer was also there in economics Nobel Prize. So this is the correct answer. But in case if 2021 economics prize is asked, then you have to know the three names of the Nobel laureates, that is David Card, Joshua Angrist, and Guido Imbens. These three persons have got the Nobel Prize in economics in 2021. Now let us see the question number 126. Limitation period for drawing up of a final decree for partition from the preliminary decree for partition is, options are 6 months, 12 years, 3 years, and none of the above. In this question, the correct answer is none of the above. Now let us see the question number 127. The limitation period to set aside an ex parte decree from the date of the decree where the summons or notice was not duly served from the date when the applicant had knowledge of the decree is, option 1 90 days, option 3 30 days, option 3 years, and option 4 6 days. In this question, the correct answer is 30 days. Now let us see the question number 128. A was allotted a plot of land by the Union of India. The allotment was cancelled and the said cancellation was upheld in a writ petition till the Supreme Court. A was, however, given liberty to file a civil suit and seek compensation. A files a suit for the compensation. In the suit, options are: the findings of the final judgment in the writ petition would not operate as res judicata. The findings in the final judgment in the writ petition would operate as res judicata. And option 3, the findings of the final judgment in the writ petition would operate as res judicata, the issue decided. And option 4, the findings in the final judgment in writ petition would operate as res judicata qua all issues. Here the correct answer is option 3, because the findings in the final judgment, according to this question, in the writ petition would operate as res judicata, the issue decided. You have to know about the doctrine of res judicata. The doctrine of res judicata operates as a bar on the jurisdiction of a court to try a suit which has been conclusively decided by the court with the same party, same subject matter under the same title. And it has been given in section 11 of the CPC. Correct answer is option 3. Now let us see the question number 129. A suit for the declaration and injunction is filed between family members. The defendants make a counterclaim. The parties are referred to mediation and a settlement is entered into between the parties. The plaintiffs has paid the court fees on the suit. The defendants has also paid the court fees on their counterclaim. In view of the settlement, options are: only the plaintiffs are entitled to refund of court fees, only the defendants are entitled to refund of the court fees. Option 3, both parties are entitled to refund of 50% of the court fees paid. And option 3, both parties are entitled to complete refund of the court fees. Here the correct answer is option 4, both parties are entitled to complete refund of court fees. Now let us see the question number 130. The court is entitled to give a summary judgment on a claim in a commercial dispute. Options are: only in favor of the plaintiff if the defendant has no real prospect successfully defending the claim, only in favor of the defendant if the plaintiff has no real prospect of succeeding in the claim and there is no other compelling reasons why the claim should not be disposed before recording oral evidence. And option 3, in favor of the plaintiff defendant as the case may be if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim. And option 4, against the plaintiff or defendant if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim as the case may be, and there is no other compelling reason why the claim should not be disposed of before the recording of oral evidence. In this question, the correct answer is option number 4, against a plaintiff or defendant if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim as the case may be, there is no other compelling reason why the claim should not be disposed of before recording the oral evidence. Now let us see the question number 131. Company A is the registered trademark holder of the mark White, VITE specifically. In respect of pens, Company B adopts the name White, VITE in respect of the ink. The adoption by Company B constitutes infringement, passing off, both infringement and passing off, neither infringement nor passing off. In this question, the correct answer is option 3, both infringement and passing off. Now let us see the question number 132. XLLC, an American company, is the owner of a registered trademark and carries on business across the world. It conducts business in India through its franchisees including Delhi and Mumbai. B. A Mumbai-based party using an identical trademark issues an advertisement in Delhi seeking application for appointing franchisees in Delhi. XLLC files a suit for permanent injunction to restrain B from infringing the trademark before the court in Delhi. B raises an objection as to the territorial jurisdiction. Options are: the suit would not be maintainable as B is based in Mumbai. Option second, the suit would be maintainable under section 134 of the Trademarks Act. And option 3, the suit would be maintainable both under section 20 CPC and section 134 of the Trademarks Act 1999. Suit would be maintainable only section under 20 CPC. In this question, the correct answer is option number 4. Suit would be maintainable under section 20 CPC. Section 20 CPC talks about other suits to be instituted where defendants reside or cause of action arises. So here the correct answer is option 4. Now let us see the question number 133. Under trademark law, the rights of the prior user are superior than that of the registered proprietor of the mark. Options are true. Option second, false. Third, it is contingent upon the prior user proving registration. And option 4, the registered proprietor can interfere with the rights of the prior user. Correct answer is option 1, true. Under the trademark law, the rights of the prior user are superior than that of the registered proprietor of the mark. This is the correct statement. Now let us see the question number 134. An architect of a building which is intended to be demolished institutes a suit for permanent injunction averring that his copyright in the architectural drawings and designs will be affected by the demolition of the building. Options are: the architect has no right to seek injunction against the demolition. The architect has rights under the Copyright Act 1957 and can seek an injunction. The architect has rights under Copyright Act 1957 and can seek injunction only if the building is situated in a city declared by UNESCO as a heritage city. And option 4, the architect can obtain injunction but only if the owner to whom he has sold the architectural drawings and design of the building is made party to the suits and the consents of the injunction. In this question, the correct answer is option 1. The architect has no rights to seek injunction against the demolition. Now let us see the question number 135. Industrial drawings were used in the production of more than 50 devices by an industrial process. The plaintiff, who is the owner of copyright of these industrial drawings, does not have a design registration. It shall, options are, have rights under the Copyright Act 1957, not have rights under the Copyright Act 1957, have rights under the Design Act 2000 along with the Copyright Act 1957, and option 4, have rights only under the Design Act 2000. Here, the correct answer is option 2, does not have rights under the Copyright Act 1957. Now let us see the question number 136. Under the Commercial Codes Act 2015, options: time period for filing the written statement is 90 days and is not extendable for any reason whatsoever. Time limit of 120 days for filing the written statement is extendable as per Kailash versus Nanku. The time limit of 120 days for filing the written statement is not extendable. There is no limitation for filing the written statement. In the given options, the correct answer is option number 3. The time limit of 120 days for filing the written statement is not extendable. This is the correct answer. Now let us see the question number 137. An order which refers parties to arbitration under section 8 of the Arbitration and Conciliation Act 1996 is: options are appealable under section 13 clause 1 of the Commercial Codes Act 2015, not appealable under section 13 clause 1 of the Commercial Code Act 2015, appealable under section 37 clause 1 clause A of the Arbitration and Conciliation Act 1996, appealable under section 96 of CPC. In the given option number 2 is the correct answer, not appealable under section 13 clause 1 of the Commercial Codes Act 2015. This is the correct answer. Section 13 of the Commercial Codes Act talks about the appeals from decrees of commercial courts and commercial divisions. Now let us see the question number 138. A boy posts some ex facie defamatory comments about his friend on Facebook. The friend is offended by the content and files a suit for defamation seeking injunction for removal of the content and damages. Facebook Inclusive is also pleaded as defendant. If the contention of Facebook Inclusive that is not liable for any damages and shall comply with any direction of the court. Options are: there is merit in contention of Facebook in view of the section 79 of the Information Technology Act 2000. There is no merit in the contention of Facebook and it having provided its platform for the content to be published is liable for, like a newspaper, for the defamation affected through its medium. Option 3, there is merit in contention of the Facebook in view of the section 66E of the Information Technology Act 2000. There is no merit in contention of the Facebook in view of its express liability under Section 79 of the Information Technology Act 2000? In this question, the correct answer is option 1. There is merit in contention of Facebook in view of the Section 79 of the Information Technology Act. Now let us see the question number 139. The Supreme Court has struck down which of the following sections of the Information Technology Act 2000? This is the very important question and this has been asked in various examinations. The correct answer is Section 66A, and Supreme Court has struck down this section of Information Technology Act in Shreya Singhal versus Union of India. Now let us see the question number 140. A certificate under Section 65B of the Indian Evidence Act 1872, which was inserted by the Information Technology Act 2000, must contain the following. Options are: identification of the electronic record containing the statement sought to be given in evidence, describe the manner in which electronic record was produced, signatures of a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities. Option 4, all of the above. In relation to Section 65B, all of the options are the correct answers. So let us see the question number 141. Which of the following statement is not true in relation to the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002? Options are: it was introduced in order to expedite the enforcement of security interest and to provide a central database of security interests created on property rights. Option second: it was preceded by an ordinance promulgated by the President in 2002. And option 3: it had been amended 4 times since it came into force. And option 4: it applies to all loans without monetary limits and also to security interest on the agricultural land. Correct answer is option 4. Option 4, it applies to all loans without monetary limits and also to security interest in agricultural land. This is the correct answer. Now let us see the question number 142. A. Who is a wholesale dealer of hosiery at Gandhinagar, Delhi, purchases goods worth 10 lakhs from B, who is a manufacturer of hosiery clothes at Tirupur, Tamil Nadu. A. issues 4 checks of 2.5 lakhs each, drawn on a nationalized bank. B. deposits the first check at the branch of X, his bank at Tirupur, which is also nationalized bank and with whom he is maintaining his account. It is honored. While on a business trip to Coimbatore, Tamil Nadu, B deposits the second check at the branch of his bank at Coimbatore, where to he maintains an account. The Coimbatore branch of his bank sends him a written memo informing that check has been returned due to insufficient funds. B files a complaint under Section 138 at Coimbatore. He presented the third check, Tirupur, which was also dishonored. Where can B file the second complaint under Section 138 of the Negotiable Instrument Act 1881? Total 3 checks issued. First was in Tirupur, second was in Coimbatore, and the third was in Tirupur again. In Tirupur, check was cleared. In Coimbatore, check wasn't clear, it was dishonored. And again the third check in Tirupur was dishonored. So we have to find the correct answer in the given options. Now the question, option 1 is, option 1, the second complaint will have to be filed only in the same court even if it does not have territorial jurisdiction. Option 2, he can file the complaints only at Delhi. This is the wrong answer because Delhi was not in the picture. Coimbatore and Tirupur was in the picture. He can file one complaint before the competent court at Coimbatore in respect of the check dishonored on the presentation there, and the other complaint at Tirupur in respect with the check dishonored the presentation at Tirupur. This is not the right answer. He can file complaints as per his convenience before the competent court at Delhi, Coimbatore or Tirupur. Again, Delhi is given here, otherwise this could have been the right answer. But option 1 in the given option is the correct answer. The second complaint will have to be filed only in the same court even if it does not have territorial jurisdiction. Now let us see the question number 143. Which of the following statement is incorrect? The prosecution against director is maintainable even when prosecution against the company is dropped because of the winding of proceeding against the company. Option 2, no director can be prosecuted under Section 141 of the Negotiable Instrument Act 1881 unless it is averred in the complaint that he was directly or indirectly in charge of and responsible for the affairs of business of the company at the time when the check was issued. Now, option 3, the issuance of the check is presumed to be towards legal liability. Stop payments instructions are not considered as dishonor of a check. In the given question, in the given options, it has been asked to find the incorrect answer. The incorrect answer for this question is option number 4. Stop payment instructions are not considered as dishonor of check. This is the incorrect statement. Therefore, is the right statement in the given question. Now let us see the question number 144. In a recent decision of the Supreme Court reported as Bajrang Shyam Sundar Agarwal versus Central Bank of India 2019 SEC, while dealing with the rights of tenant vis-a-vis the rights of a secured debtor under the Securitization and Reconstruction of Financial Assets Enforcement of Security Interest Act 2000 SURFACI Act, which of the following propositions was not laid down? Options are: if a valid tenancy under law is in existence even prior to the creation of a mortgage, the tenant's possession cannot be disturbed by the secured creditor by taking possession of the property. The lease has to be determined in accordance with the Section 111 of the Transfer Property Act 1881. The rights of the rightful tenant cannot be compromised under the SURFACI Act proceedings. Option second: if a tenancy under the law comes into existence after the creation of a mortgage but prior to the issuance of notice under Section 13 Clause 2 of SURFACI Act, it has to satisfy the condition of Section 65A of the TPA. Option 3: in any case, if any of the tenants claims that he is entitled to possession of a secured asset for a term of more than 1 year, it has to be supported by the execution of registered instrument. If the tenant relies on an unregistered instrument or an oral agreement accompanied by the delivery of possession, the tenant is not entitled to the possession of the secured assets for the more than the period prescribed under Section 107 of the Transfer Property Act 1881. And option 4, the rent control legislation, if any, restricting eviction of tenants save on the grounds provided therein, if applicable to the tenancy, prevails over the provisions of the SURFACI Act. In this question, the correct answer is option number 4. This is the right answer. Now let us see the question number 145. What is the effect of filing of a winding up petition by a secured creditor before the company court after issuance of the recovery certificate under the Recovery of Debts Due to Banks and Financial Institution Act 1993, as per the decision of the Supreme Court in Swaraj Infrastructure Private Limited versus Kotak Mahindra Bank Limited 2019? Options are: subsequent winding up proceedings will be barred, stay of winding up proceedings. Option 3, stay of proceedings under the Recovery of Debts Due to Banks and Financial Institutions Act 1993. Both may be prescribed in parallel. In this question, the correct answer is option 4, both may be proceeded in parallel. Now let us see the question number 146. After the decree of recovery of debt due to the bank is made by way of issuance of recovery certificate by presiding officer of the DRT, the recovery officer can: option 1, attach and sell the movable and immovable property of the defendant. Option B, arrest the defendant and detain him in prison. And option 3, appoint a receiver for the management of a movable and immovable properties of the defendant. In this question, all the statements which are given are the correct statements. So in the given options, option 4 will be the right answer because all the statements are the right statement. Now let us see the question number 147. Which of the following statements are true to ascertain whether a document creates a license or a lease? If a document creates an interest in the property, it is a lease. However, if it only permits another to make use of property of which legal possession continues with the owner, it is a license. Option second, the real test is the intention of the parties, whether they are intended to create a lease or a license. Option 3, the substance of a document must be preferred to the form of the document. And option 4, if the party gets exclusive possession under the document, he is prima facie a tenant, but circumstances may be established which negate the intention to create a lease. Now let us see the options. Options are: only first and third are correct, only first and second are correct, and only third and fourth are correct, and option 4, all are correct. In the given question, all the options are the correct options. Now let us see the question number 148. Under which provisions of the SRA specific performance of a contract may be enforced when the promoters of a company have, before its incorporation, entered into a contract for the purpose of the company, and such contract warranted by the terms of incorporation is accepted by the company and communicated to the other party under Section 20A, Section 19, Section 17 or Section 20. In the given question, correct answer is option number 2, that is Section 19. Let us see the question number 149. Which of the following statement is not true? Here we have to find which is not true. The options are: in a suit filed for a specific performance of contract for the transfer of immovable property, no relief for refund of earnest money can be granted by the court unless specifically claimed. Option 2, the dismissal of a suit for a specific performance of a contract or a part thereof shall bar the plaintiff's right to sue for compensation for breach of such contract or part, and shall also bar his right to sue all other reliefs by reason of such breach. And option 3, a court may refuse to rescind the contract where the plaintiff has expressly or impliedly ratified the contract. And option 4, no relief for rectification of an instrument shall be granted to any party under the Section 26 unless it is specifically claimed. In question number 49, correct answer will be question number 2 because this is not the true statement in the given options. Statement 1, 3rd and 4th are the right statement and the question is asked which is not true. This is not true, so the option 2nd will be the right answer. Now let us see the last question, question number 150. Which of the following court cannot grant in its discretion under the Specific Relief Act 1963? Declaration, simpliciter, mandatory injunction, damages in lieu of injunction, an injunction to prevent the breach of a contract, the performance of which would not be specifically enforced. Question is, which of the following the court cannot grant in its discretion under the SRA? Correct answer is 4. In SRA, an injunction to prevent the breach of a contract, the performance of which would not be specifically enforced, will not be granted. So this is the correct answer. Here we will wind up this video. In another video of this playlist, we will discuss the next question paper of Delhi HJS. Thank you for watching. Please like, share and subscribe. And one more thing, we have made a new Telegram channel. Channel will be a discussion forum. Please like, share and subscribe and share with your friends. Thank you so much.